here in DC, live in Wisconsin, and taught this program for 15 years. So looking forward to hearing about you.
Well, good morning, judges. Thank you for being with us. We're Reno High School's Unit 2. I'm Nate McKay, and I'll be attending the University of Southern California.
I'm Paul Lessard, and I will be attending Texas A&M University.
I'm Kira Goris. I'll be attending the University of Nevada, Las Vegas.
I'm Nico Howe. I'll be attending Marion Military Institute. Our teacher is Mr. Richard Clark. Our unit coach is Mr. Henry E.
Thank you. Now for what you wanted. At least you didn't have to wait all day like yesterday, right? Okay, so Unit 2, Question 1. According to one historian, most anti-federalist leaders disparaged Madison's proposed amendment, which they considered positively harmful because their enactment would be likely to reduce the prospects of securing the sort of amendments they deemed necessary. What sort of amendments did the anti-federalists think were necessary? What were the anti-federalist objections to Madison's proposed amendments, and what additional rights, if any, should be added to the Constitution? Explain your position.
Inscribed on the Liberty Bell are the words, "Proclaim liberty throughout all the land and unto all inhabitants thereof." From the signing of the Declaration of Independence to the Constitution, Independence Hall serves as the gathering place to forge liberty. However, the natural rights philosophy enumerated in these founding documents has evolved beyond the walls of Independence Hall, as some of the earliest amendments sought to fundamentally change the Constitution's governmental structure.
The Declaration of Independence defines liberty as one of the inalienable rights that all men are entitled to. Colonists wrote state constitutions and implemented state governments to preserve such fundamental rights. Among the original colonies, every state constitution included a provision for trial by jury, as well as freedom of speech and expression. During the Philadelphia Convention, anti-federalists such as Robert Yates hoped to protect these rights in a Bill of Rights. In Brutus II, Yates cites Article 6, Section 2, writing, "It is positively expressed that the different state constitutions are repealed and entirely done away."
Though James Madison initially resisted a Bill of Rights, he later stated that it was necessary to make the Constitution better in the eyes of those who were opposed to it without weakening its frame or abridging its usefulness. With the exception of the 10th Amendment, Madison drafted amendments that secured individual liberties without changing the Constitution's fundamental structure. The purpose of these amendments was to fulfill the pre-ratification promise of a Bill of Rights, reduce anti-federalist sentiment for a new constitutional convention, and convince holdout states to ratify the Constitution.
However, the anti-federalists believed structural amendments to the Constitution were necessary, with Richard Henry Lee writing that while Madison's proposed amendments had sufficiently enumerated personal liberties, right without power to protect it is of little avail. Anti-federalist William Grayson argued that the proposed amendments were good for nothing because they did not limit congressional taxing power in Article 1, Section 8, or reduce the scope of the federal judicial jurisdiction. With the intention of reducing federal power, the anti-federalists proposed multiple failed amendments.
Harvard law professor Michael Claremont describes these amendments in the Framers' Coup, including amendments to limit Congress's ability to lay direct taxes without funds from the states, or the power to restrict Congress's power to restrict the times, places, and manner of federal elections, as established in Article 1, Section 4. Similar to many state constitutions, anti-federalists proposed amendments that would allow constituents to restrict their congressional representatives.
In regards to which rights we think should be added to the Constitution, we advocate for congressional representation for the District of Columbia. In Federalist 43, James Madison defends the creation of a federal district in Article 1, Section 8, as a necessary protection from state interests. However, since Washington, D.C. was established with the Residence Act of 1790, the city has transformed from removed governmental quarters to the 21st most populous city in America.
In 1961, the 23rd Amendment guaranteed Washington, D.C. the same number of electoral college votes as the least most populous state, effectively making D.C.'s electoral weight the third most powerful. However, the 600,000 residents of D.C. are still not represented in Congress, where the laws passed there will affect their interests. This violates John Locke's philosophies of representative government and legislative supremacy. As Locke states, any laws over the people must be made either by themselves or by the representatives chosen by them.
Efforts to expand the voting rights of D.C. citizens have met constitutional pushback, as illustrated in the 1949 case of National Mutual Insurance Company versus Tidewater Transfer Company, in which the court did not expand representation rights to citizens in federal territories. Further, numerous legislative actions, such as the District of Columbia Voting Rights Act of 2009, have failed to pass both houses of Congress. A constitutional amendment will guarantee DC representation in both houses of the legislature. Thank you.
Okay, talk a little bit about the amendments that the Anti-Federalists were proposing. Why were they going that direction?
Well, essentially, the main argument from the Anti-Federalists was that they wanted a Bill of Rights specifically enumerating the rights that were proposed by their side of it, not only their side, but also proposed by Federalists that were not as distinctly shown throughout the Constitution. They wanted this because, as Saul Cornell points out, a constitutional scholar, he says that the Anti-Federalists wanted people to be educated on the rights that they have so that they can be effective at protecting them.
George Mason refused to sign the Constitution unless if there was a Bill of Rights within the Constitution. He figured that even though state constitutions already had such provisions for individual liberties, that if they were not explicitly protected within the Constitution, then they could easily be trampled by the federal government.
Further, we also have this idea that the Anti-Federalists really wanted to feed into Edmund Burke's idea of a delegate theory instead of a trustee or politico. They wanted these amendments that would allow constituents to tell their representatives how they wanted them to vote, so that it would ultimately be the people's voice being represented in this Republican government.
They wanted this because they saw through the Articles of Confederation this lackluster government that wasn't great at representing the people, and that they relied so much on state sovereignty instead of what they thought of as tyranny by the British Parliament.
But weren't the Anti-Federalists in fact pushing for more state sovereignty? Wasn't that the whole thrust of what they were arguing for?
Right, yes, I'm not sure if I was clear on my last point. The Anti-Federalists wanted the Articles of Confederation to simply be amended. They didn't want what the Federalists came for, which was a whole other constitution with more governmental power. Whereas the Anti-Federalists were fighting for more state sovereignty. You're absolutely correct. What I meant by my last statement is that through the Articles of Confederation, they found that there were problems with how they were being represented, and they wanted more effective representation through the Articles of Confederation, not necessarily through a new document altogether.
So why is it that Madison initially opposed a Bill of Rights? What was his argument?
Madison believed that within the body of the Constitution, the Bill of Rights had already existed in some sort of way, that these rights were already protected, although they were not explicitly enumerated within the Constitution. He wrote them in an order so that you could find, his original 19 that he drafted, so that you could find them specifically in that same order within the body of the Constitution.
Madison also wasn't, he was moved by the convention. He came early, he came there to learn. He wasn't as stubborn as some of the other Federalists or Anti-Federalists that we saw, like Robert Yates, who stayed for a month and then left. We saw that he was ready to adapt to these ideas, that what the people wanted and what the delegates that were representing the people wanted. And because of this, you can see his change of heart through his Federalist Papers even, where in Federalist 39 he says that there needs to be a Bill of Rights, although he opposed it originally because it's what the people wanted.
On top of this, Alexander Hamilton also really wanted an elasticity within the Constitution, because if you were to lay out every single right enumerated in the Constitution, then it wouldn't allow for any kind of push and pull. So he wanted these elastic clauses that would really allow for more change as time went on.
This is described in Federalist 84, what Paul is referring to. And we can see this idea of rights that are alluded to, such as freedom of speech in Article 1, Section 6, which allows for the free speech of congressmen without punishment from the government, or also Article 6, Section 3, religious freedom is alluded to, and that not all congressmen will be required to take a religious test as a qualify for office.
One of the pieces in your opening presentation, you talked about a fear of the Anti-Federalists, or concern structurally, was the judicial jurisdiction. Should we still be concerned about that, and why?
Absolutely not. We should not be concerned about the judiciary branch. Alexander Hamilton said in Federalist 15, he proposed the question, why institutionalize government at all? And he answered himself in saying, because the passions of men cannot be conformed to the dictates of reason or justice. And this is why we have a judiciary branch. This is why we need this check on other parts of the government, and this is what anti-federalists needed to take into consideration.
I would disagree with Kira, and I would say that point to Justice Anthony Kennedy himself, who said that any court or any country that relies on 9 individual justices to solve unelected justices to decide the most controversial and pressing issues in our country isn't a true democracy.
I disagree with Nate. The courts are not all that powerful because in 1995, the Supreme Court decided in the case of Pollock versus Farmer Loan Trust Company that you cannot have an amendment for a federal income tax, and Congress undid that by the 16th Amendment, which gives federal income tax.
I believe what Paul is trying to say is they didn't say that you can't make an amendment allowing an income tax. You can't make a statutory law, which is what Congress did to propose this income tax. And Congress went around the Supreme Court to institute this, what became the 16th Amendment allowing the income tax.
All right. Thank you.
Okay, I really liked your prepared remarks. I thought you really captured what I think is the essence of this question. In looking at the conflict between the anti-federalists on the structural issues. And I really liked that you cited a number of specific examples of amendments that the anti-federalists were proposing on taxing federal jurisdiction, control of elections, instructing representatives. I like that a lot. I will say that I think you kind of slid off that focus in the answers to questions. This is kind of a tricky question, and people wind up talking a whole lot about the content of the Bill of Rights as it exists today, that we've come to cherish and love. But it sort of gets past that real true conflict between the Federalists and the Anti-Federalists before we got to that. So I think I would have liked to have heard you stay on your theme a little bit more in the response to questions. But it was a good presentation.
Yeah, I would agree that your prepared remarks were excellent. You walked us through natural rights to state constitutions and then laid out the structural elements. It was very easy to follow, very thorough. I thought you did a really nice job with it. I thought your responses to the questions were good. I was hoping for a little bit more specifics, pointing to places in the Constitution that Madison would have argued. So, you stated that that was his argument, but pointing to specific examples within the Constitution that he would have argued at the time would have been helpful. I also think a little bit more complicating the story about the debates between the Federalists and the Anti-Federalists, that there were some sort of underlying, ideas about breaking up the Anti-Federalists and things like that that were just complicating that historical piece of it and getting into more detail about the debates between the Federalists and the Anti-Federalists and where they were coming from.
I think you did a great job in your opening statement. It flowed. I understood where you were going. You grounded it in the concept of liberty and natural rights, which is a really good thing to do. And how it flowed in terms, I really liked to hear the state constitutions and their declarations of rights, where we got that meat from. So you really gave us a really good historical frame to better understand the concept in between the Federalists and Anti-Federalists on this issue. In your follow-ups, I think you gave some good examples. What I liked most in your follow-ups is that you really worked together in terms of supporting each other, giving examples, and for instance, Nate, when you went and clarified what Paul was saying with specifics from the Constitution, right? That's what we want to hear. We want to hear where in the Constitution Madison says, like you were talking about. Or anytime that we ask a question, we want to know, kind of going back into the Constitution, where these principles are. Love hearing Federalist 84, thank you. Always love hearing about the Federalists. But I think just some food for thought in terms of moving forward is thinking about what were the grounding principles of the arguments, right? They all believed in really core principles, one being liberty. But what are the other ones, and how do they see that differently? And how does that roll out into what happened with the Constitution and today? Like, those are still the fundamental principles we believe in, I hope, for the most part, today. And how are we still grappling with them? I mean, there's still, how do you see these Federalist, anti-Federalist debates happening today? I liked your DC example, it was very interesting in terms of that. I'd also look at, just for background, look at positive and negative rights, all those fun things that you can do in Unit 2. But I think you did a really nice job overall with both your opening presentation and your follow-ups. So you should be proud. Thank you.